Is it Thursday yet? Yes, we are in fact live. Happy Halloween, everyone. At least the day before. Halloween Eve, right? All Hallows Eve. Ooh. Ladies and gentlemen, it's the day before Halloween, and we are live on Lone Wolf's Court Gallery. And ladies and gentlemen, we have a full show for you tonight. It's gonna be some crazy stuff in store. I've put together the best of today, and I gotta tell you, I'm kind of proud of this compilation we got going here tonight. We're going to start with Judge Hessling. We're going to go to Judge DeSanto. We're going to end with Judge Simpson in the most Simpson way possible. And ladies and gentlemen, you know how we do this. You know how this goes. Because every single Saturday we do it live, just like we're going to do it tonight. So come by and hang out with us on Saturday too. But right now, we have some court to watch. To make sure you don't get yourself in trouble, or we'll be watching you too. It all starts right now.
Good morning, everyone. Welcome to the 87A District Court.
Now, just to throw this out there, we don't normally do this. This is not a thing I normally do. But since Granny was so kind at the very beginning of the show to throw out a little $2 donation to the channel, I'm going to say thank you very much, Granny. You are the kindest person I know out there with Rhonda, Jerlay, Wolf, Bromedicus, Mama, everybody in chat. Thank you so much for being here tonight. We are live, ladies and gentlemen, and we're getting it started. Thank you all for being here. I don't know why I'm stalling like this. I never do this. We're live, and I'm doing it different because, you know, pausing's what we like sometimes, right? No, bye.
Judge Hessling will get started with the criminal docket this morning. First case is the State of Michigan versus Dawn Crow. It's file 23-42445-SM.
As a matter of fact, we're going to forget any of that ever happened. we're just going to back up. We're going to say no more because Colin's coming. We're timing out. We're having our proverbial, our required Colin when we're live, and Colin raids. We must have the proverbial Colin pause. So, ladies and gentlemen, in honor of the oncoming Colin Raiders, ladies and gentlemen, the required Colin pause is in effect. Hi, Raiders. We waited just for you. I knew you were coming, so I did the Colin pause. Well, first I said thank you to Granny for a really kind donation at the very beginning. And then I said, oh, look, Colin's about to raid. So I've got to pause anyway because whenever I'm live, we have to do a required Colin pause. So, ladies and gentlemen, from Colin World, the Cooligans, the coolest of the Cooligans, showing up over here tonight. Thank you for being here. We are in the midst of the obligatory Colin pause. Thank you, Thurina. I could not think of that word for the life of me. I was dying over here. I really was. I was like, what is that word? Anyway, we haven't really started the show yet. We have started the show and then I restarted the show. But anyway, I'm going to disappear from the screen right now and then I'm going to start the show and we're all going to watch it together and it's going to be an amazing and it's going to be a funny, fun thing. And it all starts right now. I think. Wait. What? Hello? Cat. Start the show.
Good morning, everyone. Welcome to the 87A District Court. I'm Judge Hesselink. We'll get started with the criminal docket this morning. First case is the State of Michigan versus Don Crow. It's file 23-42445-SM. We have Ms. Crow with us. Yes, I do see her there. Ms. Crow, this is a probation violation hearing. Looks like we adjourned things for 3 months back in July. The allegation is that you are non-compliant with your probation and that you failed to complete the retail fraud class, work camp days, report for the month of July, pay your fines and costs, and test as required. Tell me how you've done the last 3 months.
So, I have gotten a job since then. I work at the Rose City McDonald's. There was a problem with my paychecks where there's something taking $300 out of my paychecks every month. So my checks were only being 100 to 200 every time I get them. I haven't been able to pay on my class. I should be able to within my next paycheck. With the community service that you guys gave me, the reason that is not done is because the guy's name is Jared. I was going through the Art Federation. His house burnt down and he hasn't been back. It's been 3 weeks. He's due back next week. I can get the 3 days done immediately. I'm supposed to have my son for Halloween. I've been trying to do better. We have had property taxes, which we're behind on, and our electricity got shut off. We had to pay that. I understand I've had a while to get this done, but if given another 3 months, Your Honor, I can honestly be off of probation by next month with all of my fines paid. I'm in a better situation now. I'm currently with somebody that is willing to help me get my life in order. He's willing to help hold on to my money so then I can make sure everything's paid and make sure everything's done. My vehicle broke down, so we've been down to one vehicle. It rusted out on the sidewall, and then my muffler is just hanging there, slapping on the bottom of my truck. So we're down to one vehicle now. But honestly, Your Honor, I can be off of probation by next month. The hours are there at work.
Did you do your retail fraud class?
No, Your Honor. I can get that done within my next paycheck in 2 weeks. I just haven't had the money. My last paycheck was only 17 hours because I was in the hospital. I have been in and out of the hospital with my kidneys and with having pneumonia. I'm currently not allowed back at work until I can get discharged from the hospital because I had walking pneumonia. I'm at home, but I have to get cleared, asymptomatic, if that makes sense. I can't have any coughs or throwing up or anything for a week before I can go back to work because I work in fast food.
So what you're telling me is you haven't finished anything, right?
Your Honor. No, Your Honor. I just now have been able to get tested down here. The hospital said that they would start testing me if there's something from the probation officer, because they asked me the last time I was at the hospital. I asked them at the last time I was at the hospital to drug test me, and they will. I could not find anywhere to drug test me down here. I moved it all the way to Lupton. I no longer live in Gaylord. I live in Rose City, West Branch area.
I know that there are testing places in the Rose City West Branch area.
I did not know that. Honestly. I have been looking
they have a district court and a sheriff's department in West Branch. You can go there and figure out how to
I went to the probation office there. They told me unless they had something from my probation officer, they could not test me. I went to the courthouse. I went to the jail. They have called Natasha. And I have called Natasha numerous times about this. And I honestly have an appointment next week to get everything started for disability.
Yes, Your Honor.
Ms. Hill, what are your recommendations?
Your Honor, I'm recommending that she serve 10 days jail and be unsuccessfully discharged with fines and costs preserved.
All right, Ms. Crow, you've been on probation for a year.
I understand that. It's just if I go to jail, I will lose my child. I am working really hard to get him back. That is my whole world. I'm supposed to go get him tomorrow for Halloween. I moved out of a domestic situation. I'm going to counseling. I'm trying to get on the right medications. I'm trying to work and get on disability so I can do what I need to do. I really am trying, Your Honor. And if given one last chance, I really can be off of probation next month. I have all of the means to do it.
We brought the original probation violation against you in April of this year. And then in July, so you knew from back in April that you should have been doing this stuff. Then we gave you an additional 3 months in July, and I told you that you must do all of the probation requirements. And I even said that you could do community service work instead of some of the work camp. But I emphasize that you had to have everything done in 3 months. And here we are 3 months later, and you've got absolutely nothing done. How am I supposed to? Man, whoa. Hey, you talking faster and talking over me doesn't change what I'm going to say. You haven't done a thing. So how am I supposed to give you a break when you've done absolutely nothing?
Because, Your Honor, if you don't remember correctly, my ex-husband just got pled guilty for beating the crap out of me. He is absconding from the police. I got word that he was looking for me and that he was turning himself in today from his mom. I came down here to try to better my life. I'm sorry I haven't got anything done. There's not very much to do community service down here. There's no goodwill or anything. I have been trying to get it done. But I finally found a place I can get it done. The only reason why it hasn't been is because his house caught on fire. I will make sure I get it done. I don't want to lose my son.
I'm sorry,
I've been
man.
trying to do a better life. I'm supposed to pick him up for Halloween tomorrow. I go to jail. His dad will take him from me. His lawyer is in the courtroom right now. That boy is my whole life. I left domestic situation after domestic situation to get better for him.
When did you go to where you're at now, ma'am?
I've only been here 4 months and I had to leave when the stuff happened with Brandon. I was stuck up in Gaylord.
So you've been there
So I've
since
only been
June.
here for a few months.
So you've been there since June, right?
And since then, we are $1,200 behind in property taxes. We have propane that is due, that is $600. Our lights just got shut off. That was another $600. And then my truck just broke down. I can send pay stubs. I can send hospital documentation that I've been in and out of the hospital. I can send all the information and documentation that you need, Your Honor.
I don't need any documentation. The only documentation I need is, did you complete your community service? Did you do your retail fraud class? Did you report as required? Did you pay your fines and costs? And did you test as required? And all of those things are a resounding no. What you're telling me is the same thing that everybody has in their life: bills and difficulties. That's nothing new. You're going to do 10 days in jail. You're going to be unsuccessful. Ma'am, you talking faster and talking over me doesn't help anything.
I'm autistic.
You're going to do 10 days in jail, and you're going to be unsuccessful, discharged from probation with your fines and costs preserved.
Can I at least turn myself in Monday so I can go get my son?
How is that going to change anything?
So I can have my son for the weekend. I don't have him again for another 2 weeks. After that, I could be out of jail by the time I go pick him up again.
What time
At
do
least
you want to
then I
pick
can
him
have to
up?
keep my child.
If you will listen to me, you'll hear that I'm asking you a question about what time that you want to appear. So stop talking and listen, please.
I'm not sure. At least at 6 p.m. on Monday. I was going to ask if I could turn myself in the jail down here because it's an hour and a half away from there. It's almost 2 hours away.
Ma'am, that's going to cost you extra.
How is that going to cost me? Like, can I just do my time down here?
I don't control that jail. I don't have the ability to send you to that jail.
I was just asking because Brandon's going to be in the same jail.
If you want to set up something to be down there, but I'm sure it's going to cost you extra to do that because they don't have to accept you down there. The jail here has to accept you.
I don't want to be in the same jail with the guy that beat the crap out of me. I'm sorry. That'll cause more trauma. I moved down here to get away from him because I'm terrified. That's why I asked for another 3 months so I could get off of probation. He scares the hell out of me. And now you're going to have me in the same jail as him? Where I can hear him scream and yell, just like he did when he beat the hell out of me?
Ma'am, if you want to set up something to go to the West Branch jail, then set it up. But you'll report on 11/3 at 6 p.m. unless you set up 10 days in jail in West Branch.
Yes, sir.
If you fail to appear, we'll do a warrant for your arrest and you'll be picked up as soon as the police find you, wherever they find you at. You understand me?
Yes, sir.
That's all for today.
Thank you.
Let's go on the record in the matter of the City of Michigan, City of Riverview versus Pamela Bowens, 25327.
Good morning, Your Honor.
Good morning.
Morning, Jeff.
Good morning. All right. And counsel, today's the date scheduled. Oh, I'm sorry, counsel, your appearance for the record, please.
Robert Erie, appearing.
And ma'am, your name for the record, please.
Pamela Marie Bowens.
All right. Today is the date scheduled for sentencing in this matter on your client's plea to an amended charge of operating while visibly impaired by alcohol. And there was a request, I recall, regarding consolidating this case with the 25th District Court, and I stated I would consider that. However, I don't have any information regarding what is going on over there at the 25th District Court regarding your client, whether or not she's on probation, how long she's on probation for. And it's my understanding, because wasn't her initial charge there also a similar offense to here?
Yes, sir.
And that was dismissed and reduced to a disorderly conduct.
And careless driving, yes.
Okay. And so I don't know what any of those terms are. Are you on probation?
Good morning, Your Honor, again. Sorry. So I met with Janine, I want to say her last name is Mendenhall, the probation officer in Lincoln Park. She did advise me that she was getting in touch with Natalie. So they were going to basically do the same thing, work together on in terms of my breathalyzer, because I still do the local breathalyzer through the school link twice a day. I do the drug test once a week. I do AA 3 times a week. I do my community service at the fire station. I also now am with the guidance center. Judge Clifton recommended them. So I ended up going there and signing up to do the therapy as well as the substance abuse that they have there, the program. I'm not quite sure if that is something that you guys had suggested here as a band. I would like to know the FAM and the MAD or whatever those two are. Is that similar? Is there a way you can explain to me like what that is? Because I am seeing a therapist as of next week at the guidance center, but yesterday was the counselor doing my site evaluation through that. So I pretty much just go to work and stay very busy. I've never violated anything. I attend to all of my meetings. I do all of my drug testing accordingly.
Okay. And I'm glad to hear all that. And I will explain the difference in these matters. But do you have an order of probation from the 25th District Court? Do you have anything in writing that's telling me what it is your client's probation is over the 25th District Court? Because I don't, when I reviewed this, I didn't see it.
I don't have that file with me, Your Honor. I have two separate files on that, but I have been in contact with Natalie at the probation department here with respect to the effort to not duplicate the programs, and she indicated to me that that happens internally at the probation here that they are in good communication with Riverview, that they will not duplicate efforts. She did indicate to me that, for example, if you order community service and Lincoln Park orders community service, that she will have to do community service in both courts. But things such as testing and drug testing and counseling and therapy, that they would not require her to duplicate those things, and that they handle that internally between themselves and the city of Lincoln Park probation.
May I add something?
Which, just a moment, which is possible depending on the frequency of testing and whatnot, just to ensure that. Now, one of the conditions that's recommended is outpatient substance use counseling. I'm not going to indicate that you have to find a different location. I would just indicate you would continue that. Your question regarding the MAD victim impact panel, that's where you would go. You would attend a MAD meeting, and you would hear about the impacts and consequences of driving with a 0.232 blood level. That could have occurred, but fortunately did not occur as far as the consequences that there could be. The fan meeting is held once per month. It's the third Thursday of every evening, and it's a big group, and it's individuals that are in current addiction, recovery, recent recovery, decades of recovery, things of that nature. So it's very different from the MAD.
I understand. Thank you for explaining this.
You're welcome. You said you wanted something else to say?
Oh, just that since meeting with Miss Mendenhall, my sentencing there is this following week, so I am expecting to get a pre-sentence report, which would indicate what they would order.
Oh, you haven't been sentenced over there yet?
No, ma'am, I don't like to interrupt anybody, but I wanted to help you kind of get an understanding of where we stand.
When did you enter into your plea over there?
I can probably pull that data up here.
When was the last time I was here? I want to say it was like a couple
September 22nd.
22nd. I always feel like it's literally within the same
It was September 19th, Your Honor, please.
Oh, right. That was before this one. Okay. That's why I presumed that.
The date of sentencing in Lincoln Park is November 6th.
Okay. All right. Is there anything else, counsel, that you would like the court to know?
I do, Your Honor. I have had an opportunity to go with the pre-sentence report, and there are some corrections, or perhaps it's better to say clarification.
Okay.
If I can over them with Your Honor at this point.
Yes.
On page 1, at the very end of the first paragraph, under general background information, it does say, this is just a typo, it says his family life was stable. I think it needs her, should be her family life.
Yes, you're correct.
Then at the very end of that paragraph, the second paragraph, it indicates the defendant reported that she is not involved in community service. I'm not sure what they meant by community service, but she is involved in community service out of Novi. She is actually engaged in 50 hours of community service. So that is probably just a bit of a clarification. On page 2, under substance abuse and treatment history, it indicates in the second line that she hasn't had a drink since 2/18. I think it says 2/18. The date of the arrest was 2/9, and she has not had any alcohol consumed any alcohol since that date. Then this is perhaps a bit of a grammatical. Under that same paragraph, substance abuse and treatment history, actually the third paragraph, which reads the defendant reported no further illicit drug use. Then the sentence indicates she is currently doing court-ordered substance abuse counseling. It indicates 4 Novi. My client sees a difference between 4 Novi. She's doing it through Novi. She wanted to make clear that when she had her incident in Novi, that there was no alcohol and there were no drugs involved in that matter. But nevertheless, that they are engaged. She is engaged in substance abuse counseling as part of her probation.
All right. So substance abuse counseling, but there wasn't any sort of alcohol or drugs involved?
That is correct. Yes.
Well, then why is there substance abuse counseling if that, is it because?
I'm not sure. They probably did a pre-sentence report. I was not her attorney on that matter. Perhaps she can shed some light on that.
Okay.
Yeah, I think it's just because I had these outstanding matters. They just thought it was, I'm gonna assume here, thought it was best to get started so that way, if, obviously looking at the fact that I had an outstanding, whatever it's, what is it called, driving while impaired?
Yes.
They just wanted to kind of cover all bases, I would say.
Probably out of an abundance of caution.
But I
Okay.
just wanted you to know, Your Honor, that's all. I had my daughter that day. That's all.
All right. Thank you.
Well-
So my question then is, if you're doing substance abuse counseling through the Novi court, but that's with the guidance center.
Yes, so that way it covers, because Novi Court, my probation officer there, has been in touch with Natalie, because Novi is the one that had ordered the weekly drug testing. Natalie had me on a random weekly, so you never know like what day it was.
Right, that's the most effective.
Oh, it doesn't even matter to me which one it is because they have hours after I leave work, so I really don't care if I, you know. But they've been able to communicate and have access to it, so they're both able to use the same test results. So either way, I go once a week.
Right, and I can understand and appreciate that. I'm talking about the substance abuse counseling that you indicated you're receiving through the guidance center. Is that what you're receiving? Is that something that was ordered through your probation with the Novi District Court?
Yes, ma'am.
Okay. All right. I just want to make sure that that's not being duplicated through 3 courts.
Thank you.
And there is one final matter, Your Honor. If you look at page 3 of the pre-sentence report, number 5, the language reads mandatory jail for any future violations. The implication of that sentence could be interpreted as she has already had some violations. She has had no violations of any bond condition at all whatsoever. And I think what that means is she hasn't even harassed or criminal violations, but we just wanted to clarify that.
Okay, right, because there's not, you're correct.
And then when the court is ready, I will have some comments I would like.
Okay, you may proceed.
Thank you, Lana. As the court is aware, Ms. Bowens entered the plea to impaired on September 22nd, 25. We have had an opportunity to go over the pre-sentence report in full, and the changes and clarifications have already been detailed to the court. Ms. Bowens is working full-time, and since these matters occurred, she has really taken a hold of her life in a very profound fashion. She accurately detailed all of what was happening in Novi, and as we indicated, November 6th, she's going to be the Lincoln Park sentencing, but she has to reiterate and make sure nothing was missed. She engages in mobile breathalyzer 2 times a day, once between 6 and 8 a.m. and once between 9 and 11 p.m. She indicated that she has weekly drug tests. There has been, as detailed to this court, a collaboration with the probation departments, Novi, and I believe it's ultimately going to be with Lincoln Park and Riverview as well. She attends AA 3 times a week diligently. She does indeed have a sponsor. She is engaged in therapy at the guidance center. That's 1 time per week. And next week she begins, as she indicated, in psych-eval. She has been in 100% full compliance with everything that has been requested of her since this incident and these incidents have occurred. And I believe that none of these courts, when probation is over, are ever going to see Ms. Bowens again. As I say, I believe that she has taken control of things in a very profound way.
So, did you speak to Ms. Mendenhall regarding the treatment court at the 25th District Court?
25th.
Yes, we're
That's
Lincoln Park.
okay, because Novi is 52nd, so sorry. Yeah, I actually shared with her, I updated her everything that Mr. Erie just explained as well, in terms of Novi, as well as everything. I've been staying in touch with Natalie Keeter. And her desire is to basically, I'm going to use the word collab, I apologize, but basically mold the treatment together. So that way, you know, their goal is basically, she just looked at it like there's nothing else I can give you. So as long as she gets supervision, access to everything, it's like I'm already doing everything that I can possibly do in terms of all 3 boards, as long as everyone is able, as long as I'm doing obviously my part, first of all, and they're able to supervise over me. You know, her desire to have to get me to report to her and so forth was, I'm not going to say 0, but you know, she's like, one of us is just going to have to like make sure that you're doing it. That's pretty much it.
So, all right, because my thought was, if you were in the treatment court, then we could combine both matters. You could be in the treatment court with all of the conditions that would go along with treatment court. I think potentially the concern is that since you have been sober since February, that you may not have the need as far as the high need portion of the treatment court. So, okay, that would make sense. All right, anything else, counsel?
Nothing, Your Honor, other than I believe that we agree with the recommendation of the pre-sentence report.
All right.
It's shining.
Okay, and so the court does find, after hearing from counsel, hearing from Ms. Bowens, reviewing the report and recommendation, the police report, the status of the 52nd District Court probation and the 25th District Court case. The court does find there's reasonable grounds to depart from MCL 769.5. The court also finds that the following sentence is in the best interest of justice, is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Bowens and the other probation conditions and the other case in the 25th District Court, as well as the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge, and I'll go over that in just a short bit. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed or be subjected to random testing. So in this case, you'll continue with the random testing. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so you may maintain sobriety and prevent relapse, hopefully preventing this matter or any other matter from happening again. You are to continue with your outpatient substance use counseling. The rehabilitative goal, obviously, is to continue to assist you in providing coping mechanisms so that you can maintain sobriety, as well as identify other factors that may be triggers for you and how to proceed through those. You have to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and to educate about the consequences of such behavior. The court's going to also order you to participate in the fan meetings once per month, and I've already indicated what that is and what the rehabilitative goal for that would be. And the court's going to order mandatory jail for any violation. I'm not going to order any court workforce, given that you are now going to be on probation in 3 courts. I don't find that would serve any, I don't see that there would be any sort of rehabilitative condition for that one.
You say that again, Your Honor.
I'm not going to order workforce because your client, I just don't find there'd be a real rehabilitative condition for that to be met, given current status on probation in Novi and then the pending matter in 25th District Court. Any questions regarding those conditions?
I just have one question on the Your Honor. With respect to MAD, if Lincoln Park orders MAD also, would she need to go to MAD twice, once for Riverview and once for Lincoln Park, or would the court accept it one time?
I presume it would be accepted one time, but since this court ordered it first, it'd be this court. But it doesn't matter either way because the courts don't receive anything from it. It's just a matter of your client doing it. So as long as she's submitting a certificate, if it's ordered by 25th as well, she just has to submit a certificate to both. You don't have to take it twice.
I have a question.
Okay.
Can I get the information on where to call to go to this thing?
You're going to get all of that from probation before you leave today. You're welcome. Okay. The court's going to note as to the fines and costs, $300 fine, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. Since you are eligible for early discharge, up to half of that could be waived. All right. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $1,725. Keeping in mind that $450 of that could be waived if you discharge early. So I'm going to have you set up your payment plan through probation, keeping in mind that you have other courts to pay. And then you will also receive all of your instructions and your program information as well. As I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations and all monies have been paid in full, or you've made a good faith effort toward making full payment. Okay?
Remember everything.
Well, you're going to get all of that from probation as well.
Yeah.
All right. Good luck to you.
Thank you. Ma'am.
Thank you.
Great day.
You as well. We're on the record in the matter of the state of Michigan versus Jeremiah White, 251347.
Ryan John Goldwasser, P 30758 on behalf of Mr. White. Mr. White, please put your name up. My name is Jeremiah White.
All right. Good morning. Today is the date scheduled for sentencing on your client's plea to domestic violence. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, we have, Your Honor. We've had an opportunity to review the pre-sentence report. So present while reviewing that pre-sentence report was his wife was present in court today. There were no deletions or corrections to be made. The only question, yes, for lack of a better term, and we're asking the recommendation be adopted. This to be taken under 769.4A. But Your Honor, also we're asking that it appears there is a no contact provision still in effect, and he's complied with all of that. And we are asking that be removed as well.
Well, I'm going to hear from Ms. Thomas White, but there's still a PPO in effect. So, and the PPO was in effect at the time of this incident. So, yes,
I discussed that with her, and she indicated that came out of this court, nothing down there.
this court does not issue PPO.
I know it doesn't, Charlie. That's what surprised me.
So, hold on, just 1 moment. I'm showing, so this offense occurred September 11th.
That's great.
This is showing personal protection order. Not served, but there's a personal protection order nonetheless.
But it wasn't served on.
Counsel, whether it's served or not, only speaks as to whether or not your client can be arrested if there's a violation. It doesn't mean the order does not exist. So this was, it appears though, issued July 31st, 2025 from the Third Circuit Court Family Division. And it says that Mr. White is prohibited from entering onto the property on 16th Street, from having contact. So I don't even know why in the world he was at the house when Miss White received a PPO preventing him from being at the home. Well, those are some questions I have. So, the no contact order is because the PPO says no contact, which clearly they're still having contact.
I agree with her.
Which is a violation of the order. So, Miss White, if you don't feel as though you are in danger, it's your responsibility to contact the Third Circuit Court to file the appropriate motion. But this was in effect at the time of this incident, yet you had him at the home. You may, because I was going to have you address the court anyway as a named victim in this matter. So I don't even really know why he was even at the home or why you were even having contact with him.
So that was
First, I need your name for the record, please.
Thomas White.
Okay.
So that was filed by my lawyer, who said it was not entering until it was served. And
Your lawyer gave you wrong information. An order that's signed by a judge is a valid order. What the difference is that Mr. White could not be arrested if it's not served.
Okay.
Because he's not on notice. But you, ma'am, were on notice. You knew that Mr. White was not allowed to be at the home, was not allowed to have contact with you.
I was never provided the final PPO.
Who's your attorney?
Longton.
Well, you may want to have a conversation with Mr. Longton because you have misinformation and you don't even have a copy of the order. But you had to participate in those proceedings in some regard because you need to sign a statement. You need to sign the petition. The court won't put that forward without having a signed petition.
I never went to a hearing, never received notice of a hearing. All that he gave me was a complaint. I never received the final document. I didn't receive the final document until after this event, after this court got involved.
Okay. Well, I can assure you, I'm not changing any of the conditions I'm putting forth in the, I am not amending the PPO. I do not have authority nor jurisdiction to amend the PPO. I did not order the PPO.
Oh.
So from this moment on, there's no contact and Mr. White can't be at the home until there's the appropriate motion filed.
Oh.
But in any event, yeah, that addressed the PPO issue. So, because I brought that up because Mr. Gopal spoke about the contact, and things of that nature. And that's why I brought the PPO up, because I cannot modify, I cannot set conditions that would conflict with that order.
Oh.
Okay. So Ms. White, you also are here because you're the victim of domestic violence. So what would you like the court to know?
Since the complaint on 9/11, there's been a huge turnaround in him. This is the first time that he's been involved in church. He's been going to church, he's been taking our children to church. He's been going to work. He's not been missing any work. He's been attending AA meetings. He's been participating in his counseling sessions with Tim Rambo. This is the biggest change that I've seen in him in years. He has not been drinking as far as like any contact that I've had with him. He's been actively involved in our children's activities and taking the children to their activities. This is a completely different person. This is the person that reminds me of the man I married 5 years ago.
Okay. And Mr. White, how are you feeling?
This is the first time I've been in court, Your Honor. Just a little nervous about that, but I feel like I've been making a big improvement. I've gotten a raise at work. I'll start going to church, start going to AA, counseling, even see a therapist, start to do education. I enjoy spending time with the kids, and I feel like I've been making a big improvement. I regret my decisions, and actually the night, the incident, and I'd like to get even onto it, but yeah.
And so what's the status of your relationship between the two of you?
We do have a pending complaint for separate maintenance. Our hearing date is for November 7th. Ultimately, I do hope that he continues on this path and that we are able to reconcile and that divorce is not in our future, but I am prepared to take action to protect me and the children, should that not be what ends up happening. But I have seen a genuine effort on his behalf. This is, like I said, a completely different person. This reminds me of the man I married 5 years ago. And I hope that this person is here to stay.
Okay. All right. Thank you very much for coming in. Make sure you're speaking with your attorney or somebody else so that you can take the appropriate steps, because as of now, are the two of you still living at the same house?
I've been staying at my father's residence.
Yeah, so that's right. Yes. Okay. All right. We are going to have to continue to stay there. I don't know if there's any sort of possession of the home or anything of that nature, if there was any ex parte orders entered or not. Okay. Right. Thank you very much.
Thank you.
Okay, Mr. Gopal.
I don't think I can say anything more better. However, and there was also a question brought up by Ms. White about him being able to leave the state. I indicated that so long as he is complying with all the court's orders, and I guess your daughter is now,
She's in a dance competition.
she's in a dance competition. This is the first time that she'll be performing out of the state of Michigan. I think it's in next month or so. But
Congratulations. They happen to refinance your house for those competitions. Okay.
and so she, in other words, I've explained that can all be worked out so long as she's in compliance with this court's orders
Correct.
and through the probation.
And probation will give you the information as to what you need to submit prior to, with as much advance notice as possible. Okay. All right. Anything else?
Other than that, Your Honor, no.
Okay.
You've heard from both the victim as well as from my client.
Yes.
I couldn't say anything better.
Okay. All right. The court will note after hearing from counsel, reviewing the report, the recommendation, hearing from Mr. White, hearing from Ms. Thomas White, reviewing the police report as well. The court does find that there's reasonable grounds to depart from MCL 769.5. The court will also note the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. White and the legislative guidelines. The court's going to order 18 months probation. You're not eligible for early discharge. You are not to violate any criminal law of any unit of government. You are eligible under 769.4A. You are not to leave the state without the consent of the court. I know we just went over some of those exceptions. You are to report truthfully to your probation officer as often as your probation officer requires, whether in person, in writing, or virtually. You're notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to continue with your mental health counseling with an added emphasis on substance abuse. The rehabilitative goal for that condition is to continue to determine what your mental health needs are and to give you tools to assist you in coping with those. The court is going to also order, at this point, no contact with Ms. Thomas White. None. That's what the PPO says. So I don't know if the two of you drove here together. You're going to have to drive so you're going to have to get picked up some other way. You cannot have contact with each other until there's a motion filed by you or by her to terminate the PPO. All right. So if that does occur, then you can submit proof of that PPO termination to probation, at which point the court will then on its own amend the no contact order to no assaultive, abusive, intimidating contact, unless we hear something different from Ms. Thomas White.
Okay, thank you.
Okay. You're not to have any weapons or firearms or any other weapons. Do you have any of those, sir? Okay. The rehabilitative goal for that is to ensure safety. The court's going to also order you to participate in domestic violence counseling for 26 weeks. The rehabilitative goal for that condition is to increase your responsibility for your actions and to educate you about how to modify your behavior and manage potentially upsetting situations. I do believe with the removal of the alcohol, sir, that is definitely a factor in assisting you in that regard, and hopefully that will continue. Any questions regarding those conditions?
I understand, Your Honor, that after I complete the probation after 18 months, it goes off the record.
Yes.
That's understood. And I was about to bring it up.
Yes, I indicated he was eligible under 769.48. You're welcome. All right, the court's going to order a $500 fine, $100 screening assessment fee, $900 supervision oversight fee, that's $50 a month, and 18 months. $300 cost of prosecution, $75 crime victim assessment fee, $50 justice system assessment fee for a total of $1,925. Obviously, sir, that's quite a bit of money. You can set up a payment plan through probation, okay?
What was that total amount?
$1,925. Do you have any questions, sir?
No, Your Honor.
Okay. I understand that the two of you are operating under a different belief regarding the PPO, but it is a written court order. Only the court can change that. You cannot change it on your own. So make sure, I know it seems counterintuitive because you drove together, you were sitting together, but the court cannot permit the two of you to have contact. So you can't have contact with each other.
Okay.
Can't even give each other a hug goodbye. You have to leave separately. Do not be in the same vehicle. None of that. In fact, you may want to go right to your attorney's office. I don't know. All right, sir, you have to go to probation. So go to probation and somebody will be with you shortly. Thank you.
Good. Thank you, Your Honor.
Thank you. Thank you. Okay, and so let's go on the record in the matter of the state of Michigan versus Todd Holbrook, 241521. An appearance for the people, please.
Good morning, Your Honor. Mohammed on behalf of the people.
Thank you. And Ms. Woodson, your appearance, please.
Yes, good morning, Your Honor. Danian Woodson, P68870 on behalf of Mr. Holbrook.
And the council will note, or the court will note that Mr. Holbrook's appearance is not required. And today is a date scheduled for a review as well as the adjourned show cause. And I will take the appearances of the individuals that are here on behalf of the show cause.
Your Honor, may it please the court, Michael J. Nichols. My P number is 59391. I'm an attorney in private practice representing the Center for Forensic Psychiatry. Also with me, Your Honor, Dr. Todd Moore, who's director essentially of clinical staff at the CFP, and Leslie Asman. Ms. Asman's an attorney. She's with the MDHS Legal Division.
Thank you. And Miss Leslie, if you can, Osmond, can you please state your appearance for the record, please?
Good morning, Your Honor. Leslie Asman. My P number is P68917.
All right, thank you. And then Dr. Moore, your name for the record, please.
Hi, Todd Moore, Moore.
Okay, thank you. So we're here for a number of things today. And counsel, I did, Mr. Nichols, I did receive your updated hearing memorandum. However, it did not resolve some of the questions that I had for the show cause purposes. And in fact, it created a few more questions. So, Ms. Woodson, the information on the updated memorandum, which I presume you received, counsel?
Yes, Your Honor.
Okay. So, there is there's improvement mentally for your client?
It appears to be so, Your Honor. He has not been reevaluated yet. I've been speaking with someone from the Forensic Center, and they're going to try to coordinate that with his case manager for his next meeting, which is November 6th. But based on my communications with him, it seems like his competency is a lot better. I know he has been receiving treatment at the Lincoln Behavioral Medical Center.
Okay. Here's where I'm very much perplexed. Mr. Holbrook was deemed not competent, but likely to be attain competency with treatment. He wasn't getting treatment, but yet somehow he's manifested improvement in his mental health.
No, Your Honor, he's been receiving treatment since he was admitted to Pontiac General Hospital in August. Shortly after that is when you scheduled the first show cause hearing. Once he was discharged from Pontiac General, he was referred to Lincoln Behavioral Medical for outpatient treatment. And it's my understanding, I think he's receiving not just counseling, but also medication as well.
Okay, and so I'm not sure which attorney would answer this best, but if there's an order for the Center for Forensic Psychiatry to provide treatment to an individual, does that individual have the ability to decline that admittance when he's under the jurisdiction of the court and the MDHHS?
Your Honor, Mike Nichols on behalf of the CFP under the statute. If you order a person to receive IST restoration treatment, the center then triages that person. It's not uncommon for a person who's on bond to get better, for lack of a better way to put it. And that's what Dr. Moore would testify to if you were to call him. It appears that's maybe what happened here, although, and I don't know how this played out on Tuesday. I wasn't there, and the notes aren't specific about whether he was asked to stay for an RIST evaluation, but he simply didn't stay for the wrist, and that is still on the books for November 6th. So what appears to have happened here is not uncommon. A person may seek treatment through, especially if it's a private pay case, may seek treatment in the community through a provider and regain competency.
And I do recall that Mr. Holbrook went to the hospital in Pontiac, and I believe that that was because there was a psychiatric incident, correct, Ms. Woodson?
That's correct, Your Honor.
Yes, because because Mr. Holbrook has been awaiting a bed since February 19th of 2025, which is one reason why we have the show cause at schedule, because he had been waiting for a bed for so long. And then it appears to be the 6-month mark, he had a psychiatric issue, which is why he was then admitted to the hospital. And then based upon that continued treatment would be apparently why there has been some improvement in his mental health. So that does not answer the question as to why it is taking the Center for Forensic Psychiatry so long to comply with court orders regarding placement of individuals on beds, and why the Center for Forensic Psychiatry is not utilizing additional resources or other agencies to assist in the treatment. But further, my notes from the September 25th court date show that Mr. Holbrook was in triage at that particular, he was in the triage state, and he was 5th on the list. Then there was a statement that Mr. Holbrook had been referred for a bed and will probably be admitted within 2 to 3 weeks. And it appears as though it was another month or longer as to when the bed was available for Mr. Holbrook at the Walter Reuther Hospital.
Your Honor, here's the situation. I'm here to defend the center on a show cause order. And you have to find willful non-compliance with your order. Any non-compliance was not willful. The statute says at the outset 15 months or 1/3 of the maximum possible penalty. That's one of the factors that goes into triaging a person into our care flow system. And in fact, we've now complied with the court's order. He came in, he declined services. He's still on the books for a wrist. And if he comes in and we evaluate him competent, then, that part of it is done. But, I did schedule a meeting with some team leaders after we were before this court in late September. And all I can tell you is there's a statute, and Your Honor, we didn't write the statute. We didn't decide how much funding to allocate. We didn't decide how many beds to allocate. We get what we get. And we didn't invent the mental health crisis. And that's where we're at. We're doing our best. And I'm frustrated in part because I know Dr. Moore is frustrated, because last week, one of your colleagues in another court, not you, sent an email to Dr. Moore and said, hey, can somebody come in and talk to us about what's going on with this particular case? And he came in by Zoom, and that judge threatened him with contempt of court and to hold him in jail until that particular defendant was restored to competency.
Your Honor, we didn't invent the mental health crisis. We're just the poor medical professionals who are just absolute victims to it. We can't help. We can't help the system, and the system can't help us. And ladies and gentlemen, that's where we're going to Simpson.
Thank you, sir. Court does call the case of the people, state of Michigan versus Cyrus Abadi.
Wait. This is all wrong. Whoa. Word screech. That's not what I just spent all this time working on. This is.
Downstairs. Yeah. Okay, got it. Court does call the case, people versus Dwight Miller.
Ashley Feltus for the people. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Miller, Your Honor.
He's still muted.
I believe he is orange pants, white shirt, Judge.
I got it.
Oh. I was just happy I could read it.
Thank you for pointing that out. I figured out where he was. Oh, there he is. Mr. Miller, can you state your name, please?
He may be muted, Judge.
No, he's not muted. Sir, can you state your name?
On and for the record. My name is Dwight Miller. I'm American State National. I'm here to challenge jurisdiction. I'm here on special appearance to establish jurisdiction, bro.
Can we approach, Your Honor?
Your Honor, I need to challenge jurisdiction.
Okay, how are you intending on doing that?
Well, Your Honor, can you show me your how I'm supposed to do this? See, it's certain things I can't remember because y'all got me in here and I don't have access to the law books. But it's okay.
There are certain things you want me to show you?
Your delegation of power, sir.
Pardon?
Can you show me your delegation of power and your oath of
My
office?
delegation of power.
Yeah,
It came from the people of Washington County that elected me. I have a certification of election in back. You want it?
Mr. Miller, that's your
I would like
attorney.
a copy of your surety bond, please, and your oath of office.
My surety bond. I don't
Yes.
have one. I'm insured by the county.
So you don't have one? Okay. You don't have a surety bond, huh? So what's your
Mr. Miller, I'd advise not to
swear oath to the Constitution, right? Yes or no?
I'd advise you not to continue this line.
Man, I'm in here. I done got victimized this morning. Are you serious? Can I get a breakout room with my attorney or my so-called attorney?
So-called attorney? No, he's a very good attorney, and he's not a so-called attorney, and you'll not refer to him that way because as you won't be disrespected, neither will he.
Okay, may I speak with the attorney in a breakout room?
You can do that on your own time. He doesn't get a breakout room here because he's live in the courtroom.
Okay. So
what are we doing with his case now that my jurisdiction has been established?
Okay, I'm putting the motion in for dismissal because ain't no so-called witness or victim to sign a sworn affidavit against me.
Please approach, Your Honor.
And not end this? Yeah. Oh. Of course, yes, you may.
So how is y'all having a conversation without me being there?
Okay, we're back to the record in the Dwight Miller case. What I'm going to do, Counsel, you're requesting an adjournment in this matter.
I am, Your Honor. Upon information, believe there may be a new case coming. I understand Mr. Miller booked into the jail at 10 o'clock this morning.
Your Honor,
So I'm asking one week to evaluate.
I object anything she talking about. First and foremost, how was you testifying?
Yeah, what?
First and foremost, Your Honor, I want this charge dismissed, man. At no time given, the lady lied.
I know, I heard your motion to dismiss.
Okay,
I denied
listen.
it already.
Listen, Your Honor, under the Constitution, what is it exactly? The maximums of law. If something comes from a falsehood, what is that? The first words out this woman's mouth, she lied. She made a story up talking about somebody put
this woman is an assistant prosecutor.
Because nobody had no weapon.
I believe he's speaking of the complaining witness, but
the complaining witness. Not Ms.
But Mr. Miller, I would advise you not to say anything more. Given the circumstances, it may be prudent to discuss this matter further and to see there's a couple other things pending as well as a potential new charge they're indicating. This might be something we want to set over for a week.
No. I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times. I was getting assaulted with motherfucking tasers and shit. I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
Okay, but we can't resolve
I
all
never
that today.
threatened no one. The same people
I
that's
know.
making these
Okay.
statements, they all three on felony probation. They done got caught.
Okay.
Their house just got
so we
raided.
can't resolve
And then they up
that
here
today.
playing line up on me.
Okay, so look, we can't resolve that today. And I think the best thing to, so that everybody can try to figure out what's going on, is I'm going to adjourn it out a week. Rather than 2 weeks. I'll try to expedite it. Let's see if we can get to the bottom of it all. So,
Your Honor.
probable cause conference.
Your Honor.
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Bond will continue.
And I should correct my statement, Your Honor, that MAG thing we saw, we discussed at the event, I think it's just the court is going to. I don't know that it's revolving the court. Thank you.
Thank you.
So I just got railroaded, huh?
No, that's not railroaded.
Yeah,
I'll let you know when that
because I'm not consenting to none of this. The lady,
Yeah, cut him. I'm done. I'm so done. Is he gone? I feel a cold coming on for this sale. It's like a hairball. I don't know. Thank you, sir. Court does call the case of the people, state of Michigan versus Cyrus Abadi.
Good afternoon, Your Honor. Mary Stenhouse, Assistant Prosecuting Attorney.
And
On
good
behalf of the people.
good afternoon, Your Honor. With us, on behalf of Cyrus Abadi, standing to me, right? Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, but I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead, Mr.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I haven't done, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin. And I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Douse to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that, but this is the part I'm concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get.
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply, specifically in paragraph 5. My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit there and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with. So that might be something he might want to consider. And I'm not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Doss.
Thank you. This is not personal, Judge. This is professional.
Which part?
What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Barr at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say this. All the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the barn or the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority that there is on that issue is to the contrary. I believe it, I put it in writing. I provided the court with the authority. What in fact I did was, I did not submit an advocacy piece. I did not, I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now what Ms. Tanner put on the record earlier, I understood based on what the law is that Ms. Tanner on September 23rd was taking an unsupported legal position and was in a way misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out of with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner. Because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in, ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing. It is published.
But I'm talking about two different things, Mr. Doss. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule says. So, if I can go back once more. The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Okay.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr.
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?
Briefly, Your Honor, regarding the date that this is scheduled for, it's November 10th. I will likely be in trial unless it resolves starting on November 10th. So I was going to see if the court had alternative dates.
Well, the November 10th date is Judge Barr's preliminary exam date, I do believe. Well, what date did it get set for?
November 10th, Your Honor.
Okay, so first of all, there has to be an alternative date. One of the things that occurred, and I don't know upon the scheduling of this, preliminary examinations that week because of Veterans Day, which did not get caught. Normally it would have been Tuesday the 11th. It may have gotten moved to the 10th. However, Judge Barr was not available on the 10th. So the judge that would be available on the 10th is Judge Valvo, but this has been already submitted and he's got some work into it in terms of Judge Barr. There has to be a different date. And
I apologize for interrupting. I was just informed that our witnesses would be available on November 25th, if that's not available.
I'm sorry?
Our witnesses would be available on November 25th, if that's an available date.
That date is not available before Judge Barr. Judge Barr's next date is December 2nd. And just so that I'm clear, he has the 13th, but my understanding is that would not be available that week. So it would be December 2nd. Is there any objection from either side to setting this for December 2nd?
No, Your Honor, that's a good date.
Then preliminary examination of this matter will be adjourned to December 2nd. I will let Judge Barr, my staff will let Judge Barr's staff know that we moved it to that date because he wouldn't have had the 10th in any event. So we'll do it that way. Anything else?
No, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Jennifer Burnside.
For the people.
Jason Eggleton on behalf of the defendant Jennifer Burnside, who is present.
Your name?
Jennifer Burnside.
All right, you're seeking an adjournment, sir?
Yes, Your Honor. Ms. Burnside's been having some problems with testing, of which I noted the court was going to inquire on. Not sure why the dilutes are coming. As previously explained to the court, I had informed Ms. Burnside whenever there is either a dilute or a result that we didn't like to immediately either report to ER or go to DNA. She's a resident of Pinckney. The 44th Circuit up in Livingston utilizes DNA testing. So on both dates, there was dilute. She did report, as well as the THC positive, which was a negative test of DNA as well that same day. Or actually, that was a 15th out test. But she is dedicated. She's enrolled in an outpatient with key development, which begins on November 5th. She's engaged in that state police angel program. She is continue with Livingston County Advocacy Group. She's got a counselor. She's got a sponsor with 26 years of sobriety. She's attending church to celebrate recovery. And she's also got a sobriety journal that dates from the date of arraignment to present day with daily entries on everything she's doing. So in an effort to, engage in further negotiations with Ms. Feltes, with the court's permission, what we've asked is for the 2-week adjournment to address that, to see if the plea might be a possibility, and at that date, hopefully enter.
That's all correct, Your Honor.
Any objection then to the adjournment?
No, Your Honor.
Will the 20th work for you? You want the 13th?
Your Honor, I'm actually going to be out of town for approximately 30 days. I've got a trip that was 2 years in the planning. I'm going to be out from the 19th to December 18th.
Can we have the 13th, please, Your Honor?
I should set it for the 20th. It's just to mess you up. No.
Right? Yeah.
Like,
that would not be nice.
he's like, Judge, please don't play with me like that.
Yeah, you're dealing with my wife shooting me.
Set it for the 20th. No. November 13th, 2025, 9 a.m.
Thank you very much, Your Honor.
You're welcome, Bond.
Have a great day.
You do the same. Court does call the case People versus Brendan. Is it Kiriakosa?
Kiriakosa, Your Honor. Good afternoon.
Kiriakosa.
Jim Murray on behalf of Mr. Kiriakosa, who's on Zoom. He is iPhone 2.
Sir, can you state your name?
Yes, Brandon Priacosa.
All right. What are we doing on this?
Judge, we're seeking an exam date of November 20th, if you can do that.
That be, no, I don't know why you decide you want to pick your own date. You want an exam?
We do want an exam, but that happens to be a date that I know is open, for me at least.
Down there, that tattoo needle was packing in those eight.
All right, look, here's the way this works. These are the dates I got, Mr. Murray. And I can't say I'm going to give any one of them to you. November 10th, November 13th, November 18th, November 25th. Pick one.
Let's go the 18th, Your Honor.
Works for me, Judge.
Any objection from the people? I assume discovery is complete and the witnesses will be available November 18th.
Yes, sir.
Preliminary examination in this case will be set November 18th, 2025, 9 a.m. before Judge Washington. In person. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Timothy Flood.
People. And Your Honor, Joe Salmon on behalf of Mr. Flood.
This is the one
Yes, Your Honor, he's gonna change the plea to guilty this time. But he needs to state his name for the record.
Pardon?
He's gonna state his name for the record. Go ahead. Timothy Flood.
All right. Of course, I understand he's going to plead assault and battery, guilty to assault and battery, 93-day offense. Upon that count, hold on. In this form, he's pleading to an added count 2 of assault and battery, correct?
That is true.
And then the child abuse third, which is count 1, is going to be dismissed.
True.
All right, I've made those corrections on the form.
He's pleading under MCL 769.4A.
I see that. There is also defense and prosecutor agree sentence under 7694A, deferral and no upfront jail. There's also been a sentencing judge waiver.
My client understands that the judge will make the full determination, final determination.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
State your name.
Timothy Flood.
Sir, it is this court to understand that you're going to plead guilty to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right.
Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yes.
August 14, 2025, at the location of 5510 Jackson Road in Scioto Township, Washtenaw County, State of Michigan. What did you do regarding an individual that makes you believe that you're guilty of the offense of assault and battery?
I slapped my son. Do you agree that exceeded reasonable parental discipline? Yes.
All right. And you did it intentionally?
Yes.
All right. Sir, if I accept your plea, you understand that if you commit misconduct as defined in the Michigan court rules between the time of my acceptance of the plea and the time of your sentencing, the judge would not be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Defense is not.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1483. Probation sentencing will be
November 24th at 9 a.m.
November 24th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Amanda Lawrence.
Your Honor, Joe Simon on behalf of Ms. Lawrence. State your name. Ma'am.
Amanda Lawrence.
You're requesting an adjournment, 13th or 20th.
I asked Ms. Lonnie, I think she prefers the 20th. That will be fine.
Probable cause conference will be adjourned 20th, 2025, 9 a.m. Bond continued.
Your Honor, can we address one matter on bond?
Certainly.
My client is a permanent resident of the state of Florida. She's been
She
working.
is?
Mhm. She's a.
So why is she here?
That's what I was about to say.
Okay.
She
just get to the punchline.
She was working, she was, yeah, okay, she's requesting permission to go back. We will submit
To Florida?
Yes.
No.
And we will be submitting a Zoom request when she understands that will have to be approved by the court for her next court appearance.
Mickey, Donald, they all get on my nerves. Is there a response from the people regarding that?
No, Your Honor, I'm sure that Mr. Simon has explained to her that if we have an in-person hearing, she has to come back for it, and I don't have an issue with her returning to questions.
Okay. You want to go to Florida? Fine. Mr. Simon, you'll prepare the order? I hear the weather's horrible there. It really is. It's really bad.
We will.
We have never had a hurricane in Michigan. I'm just saying. No, we haven't. No, we got tornadoes, but those you can dodge. All right.
We will submit an order, Your Honor. Thank you so much.
Thank you. Bond. Nothing against Florida. Court calls the case People versus Tamara Head.
Sorry, Judge, I don't know if the.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
And good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Tamara Head. Ms. Head, can you please unmute and state your name for the court?
My name's Tamara Head.
Thank you.
Okay, what are we doing?
Your Honor,
you have
is
two prosecutors against you.
you see how they do that, Judge? They just.
I know, but don't worry about it. It's now even. Go ahead.
Thank you. This is a date and time set for PCC. I have recently been appointed to Ms. Head's case, and I need to ensure that we do have all discovery. So I would be asking for an adjournment of the PCC.
All right. The 20th work for you? Or you want the 13th? Whichever your pleasure.
Yes, the 20th is fine, Judge. Either one's fine.
November 20th, 2025, 9 a.m. Bond continued. All right. Thank you.
Thank you.
Court calls the case People versus Naya Lee.
Good afternoon, Your Honor. Jonathan Emmons on behalf of the people.
Christina Costantino appearing on behalf of Ms. Lee. Ms. Lee, can you unmute and state your name for the court?
Naya Lee.
All right. What are we doing?
Judge, this date and time set for PCC, we are asking for an adjournment of the PCC. Mr. Emmons and I have had some extensive discussions about the matter, but I do believe we need to have some further discussions as well. There is another case that is also pending that is related to Ms. Lee's case. So we would be asking for an adjournment of the PCC.
Any objection?
I don't have any objection to that, Your Honor.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m.
Your Honor, if I could ask if there's no objection from Ms. Constantino, if I could ask for a date after the 20th. I'm scheduled to be in trial that week.
You have any objection to that? I mean, I have the 25th, or my next date goes into December.
I have no objection to a different date. Let me just check.
I have November 25th, and then not another date until December 4th.
Either of those dates for me, I appreciate it, Your Honor.
Is the 25th date, is that going to be in the morning?
Yes. For a PCC, yes, it will be.
Yes, okay. Well, Judge, unfortunately, I can't do the 25th or the 4th.
Okay.
Although
I have the 11th.
the 11th would work for me.
December 11th, 2025, 9 a.m. Bond continued. See how nice I'm being?
Thank
I think
you,
Ms.
Judge.
Constantino might,
What's wrong?
I think she might have an issue for bond, to which
I
I'm
do,
not gonna.
Oh, you do?
I do, Judge. Just a brief one. Your Honor, in the spirit of the holiday season, I am asking if the court would permit
That's funny. Is
Ms.
it the holidays yet?
tomorrow, perhaps, Judge.
I hate Halloween. I don't understand it. Everybody
Aw.
dresses up funny.
Yeah, there's usually some treats, candy involved too, but Your
I
Honor,
only
we're
like chocolate.
well, okay.
So go ahead. I'm sorry. I'm interrupting your bond argument.
That's all right, Judge. I'm asking on behalf of Miss Lee if she would be permitted to, she's presently under home confinement. We're asking if she would be permitted tomorrow to take her children trick or treating from the hours of 5 to 8 p.m. We did speak with Community Corrections, who indicated this issue needed to be raised with the court. She would be going in the area of Textile and Huron Road. It's my understanding that there aren't any other adults who would be able to take the children trick or treating. So we are asking for permission for her to do that.
In the spirit of the holidays, Your Honor.
I probably shouldn't have said I hated Halloween before this, huh?
Yeah, I don't have any objection to the request being made by
If
the
you
defense.
prepare an order, I will allow that to happen. Ms.
And
Constantino, send it over to Ms. Weidling
And I'll get ahead of it. Christina, if you want to reach out to me, if there's any travel plans that are going to happen for Thanksgiving, if you want to reach out to me, I'm sure we can work that out by an order.
Thank you very much. I appreciate that.
Thank you, Your Honor.
Thank you.
Thanks.
A Halloween exception. Wow. Court calls the case People versus Keith Walker. And continuing on with the Constantino show. Go ahead.
Christina Costantino appearing on behalf of Keith Walker. Mr. Walker, can you unmute and state your name?
Keith Walker.
Thank you, sir.
Your Honor, we're asking for an adjournment of the PCC for some further negotiations.
Will the 20th work before I write it?
Yes, Judge.
It will. November 20th, 2025, 9 a.m. Bond will continue.
Thank
All right.
you.
Thank you.
Thanks.
Thank you, Mr. Walker.
Thanks.
Court does call the case of the People versus. Is that it for Ms. Constantino? Yeah. Okay. Well,
That's
you
it.
have a nice evening.
That's it for me, but I might be standing in for David Goldstein, so I'm standing by.
Oh, sorry. Okay. Court does call the case of the People versus Joel Serbinoff.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Covered on behalf of Mr. Serbinoff, who's joining us for Zoom. Joel, please state your name for the record.
Yep, Joel Serbinoff, Your Honor.
You're requesting an adjournment?
Yes, Judge, we are working on getting him into treatment court, but unfortunately he lives out of the county, and so that's presenting some complications to get it transferred.
You want the 25th?
It's excellent, Judge. Love that date very much.
November 25th, 2025.
And a brief issue as to bond. So the court had
involve Halloween.
I have no opinion on Halloween, Judge, personally. No, Judge, it does not involve Halloween.
Okay.
No, the court had previously signed an order allowing Mr. Serbinoff to test at a different facility.
Yeah.
That particular facility isn't working out very well for Mr. Serbinoff. He found one that's closer and a little more affordable for him. So we would ask that the court switch it to a different location. I
don't have a problem doing that. It would, if it's a suitable location by community correction standards, then I don't have a problem. So you can submit an order to that effect. I check with community corrections to make sure it's a suitable facility.
Understood. Thank you, Judge.
All right.
Thank you, Honor.
Bond will continue. You're welcome, sir.
Be in touch, Joel.
Court does call the case People versus Antoine Thomas.
Howard Riddell, on behalf of Mr. Thomas, who is coaching the podium, will be joining me. Mr. Thomas, please state your name for the record.
Antoine D'Angelo Thomas.
And Your Honor, again, trying to get Mr. Thomas into recovery court, but he lives out county. So it's presenting a little complications. Your Honor, pardon?
25th,
Yes, please.
November 25th, 2025, 9 a.m.
Thank you, Judge.
Is this bond good?
You bond good? We're good.
Okay, bond continues.
Right. I'll reach out.
Keep getting interrupted. Keep trying to change things. Court calls case, People versus Mark Jordan.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Tina Sachs on behalf of Mark Jordan Jr.
And Mr. Jordan, could you state your name?
Mark Jordan.
All right. What are we doing?
Your Honor, I'm requesting an adjournment to do a little bit more research on this discovery and then to speak with Mr. Overwater about it.
Will the 20th work for you?
Yes.
Probable cause conference will be adjourned without objection November 20th, 2025, 9 a.m. Bond continued. Thank you. Court calls case of the People versus Michael McLean.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Tina Sachs on behalf of Mr. McLean.
Hello.
Mr. McLean, please state your name for the court.
Michael McLean.
What are we doing?
Your Honor, we're asking for an adjournment. Mr. McLean just got into treatment last week. So we just want to, this is a review hearing, and see if we can work out a deal by the time he finishes the program in about 3 weeks.
Well, okay. Well, will he finish by the 20th or no?
He should be.
All right, November 20th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
All right, thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Matthew Morrow.
People.
Good afternoon, Your Honor. Jack Kramer on behalf of Mr. Morrow, who is present here by Zoom.
Mr. Morrow.
Matthew Morrow.
Thank you. He's waiving exam.
That's correct, Your Honor.
Mr. Morrow, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense was committed and that you committed it?
Yes, sir.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Counsel, you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And how does your client plead at this time?
Not guilty, Your Honor. Thank you.
Defendant pleading not guilty. Court will enter that not guilty plea. Pretrial will be set for
December 23rd at 1:30 with Judge Cunkey.
December 23rd, 2025, 1:30 before Judge Conkey.
Thank you very much.
Thank
Thanks,
you.
sir.
Bond continued. Thank you. Yes, you may. I have it. Court does call the case, People versus DeAndre Smith. Mr. Johnson. Oh, there he is.
Good afternoon, may it please this honorable court. Kareem Johnson, on behalf of Mr. Smith.
Good afternoon, Mr. Johnson. Long time no see, it seems.
No, Your Honor.
All right. Your name, sir?
DeAndre Smith.
All right. Okay, and what do we want to do on this, sir?
Your Honor, would like to request an examination date.
And know with discovery is complete.
Yes, sir.
Okay, we have sort of this interesting thing coming up. I have the 10th or the 13th available next week, or the 12 days out. So which one would work better for you?
Neither, Your Honor. On the 10th, I have a homicide exam in Wayne County, and on the 13th, I have several matters in the Lansing District Court.
I knew this was going to happen. All right, what about the 18th?
The 18th works for me, Your Honor, in the morning.
Okay, we did it on 2 tries. I'm good. Will that work for the people?
Yes, sir.
All right. Preliminary examination in person, November 18th, 2025, 9 a.m. That is before Judge Moore.
That's here.
Yes, it will be at this location, sir. Okay, in person. Bond will continue. All right. Thank you.
Thank you. Have a good day.
You do the same. Court does call the case. People versus Michael Lovas or Michelle Lovas.
Good afternoon, Your Honor. John Shea appearing with and on behalf of Ms. Labaz.
Your name, ma'am?
Michelle Labaz.
Okay, I mispronounced it.
Your Honor, Mr. Dawud and I are requesting an adjournment. Mr. Dawud is relatively new to the case. He's still reviewing. I have some discussions that are also on my calendar, and we would like to speak with each other prior to the next PCC because of not the Halloween holiday, but the Thanksgiving holiday is going to be on us. And
That's coming up too.
Yes, it is.
Wow.
I may be out of town. Could we have December 4th?
Any objection from the people? Not a problem. December 4th.
Thank you, Your Honor.
2025, 9 a.m. Bond will continue.
Thank you.
Thank you. Court does call the case. People versus Tabitha O'Carroll.
Ready, Your Honor. Kenneth Overwater, Assistant Public Defender, appearing on behalf of the people.
Good afternoon, Your Honor. J. Grant Miller on behalf of Miss O'Carroll. Please state your name.
Tabitha O'Carroll.
Your Honor, we're requesting an adjournment in this matter to continue some negotiations and hopefully possibly resolve this. I sent some medical records to the people, but Miss O'Carroll can't actually get in to see her specialist until the beginning of December. So I would ask for not necessarily the 4th, but the very next date the court has available, just in case if there's a problem and the people want to see those records as well.
Any objection from the people?
No, Your Honor.
December 11th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
Court calls the case of the people versus Jumaine Williams. Jumani, is that how I should pronounce it?
Yes, sir. Alexander on behalf of the people.
Good afternoon, Your Honor. J. Grant Miller on behalf of Mr. Williams. Please state your name.
Jumani Williams.
And there's 2 A's.
Yes.
That's not how I've seen this. I've seen it there.
Like Jumanji, the movie.
Oh,
wait. Never mind.
No, it didn't go over my head. I'm just like, why? Anyway, all right. What are we doing?
Your Honor, I have received the correct discovery for my client, so we're ready to set it for an exam.
People have their witnesses available the 10th.
We'll do our best, Your Honor.
All right. Preliminary examination in person, November 10th, 2025, 9 a.m. That's before Judge Balbo.
Thank you, Your Honor.
Thank you. Bound continue.
Thank you, Your Honor.
Thank you. Do you mind me? Court calls case People versus Nora Rita.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
And good morning, or good afternoon, Your Honor, to you and your staff. Jessica Holland, P 86695 on behalf of Ms. Rita. Will you please state your name for the judge?
Nora Rita, Your Honor.
I got that name, Nora. It only had 4 letters, so I was. All right. Okay, what are we doing?
Your Honor, today is the date and time set for a PCC. The people and I are in negotiations. We're hoping to resolve this matter. We're asking for an adjourned PCC.
All right. Will the 20th work for you guys?
It will, Your Honor.
During this matter, November 20th, 2025, 9 a.m. Bond will continue. Thank you.
Thank you very much, Your Honor.
Court calls the case of the people versus Scotty Chatfield.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Oh, sorry. Ellis Freeman from Scotty Chatfield. I was warned not to ask for December 2nd for an exam because I can't set my own dates.
That's true.
So
so you see how you just threw that out there, and then
that would be my distinct preference.
I understand. Sir, your
Scott
name?
Bill.
All right, thank you. You want an exam on that date?
Yes, I do.
All of your discovery is complete.
I believe it is.
And would people have their witnesses available if I were to pick a date of December 2nd?
We certainly can try, Judge. That gives us plenty of time.
All right. Preliminary examination in person will be set December 2nd, 2025, 9 a.m. That is before Judge Perry. Found in this matter will continue. And Mr. Chatfield, I'm going to say something to you, and I appreciate it. I appreciated you, just this day and age, maybe you shouldn't say it, but just being a gentleman and holding the gate open while somebody exited.
That's no problem.
I always have to point out when people do bad things. Sometimes I don't get to point out when people do good things and treat other people with respect, but I wanted to point that out. Thank you for that.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Marcia Shaquan E.
Thank you, Your Honor. Zachary Holloman on behalf of Miss G, P 78327. Go ahead and say your name for the record.
Marcia G.
Your Honor, we're just looking for an adjournment.
20th work for you?
13th or 20th, court's prerogative.
13th then. Nobody was picking that date, so you'll be here. November 13th.
Thank you, Your Honor.
2025, 9 a.m. Bond continue.
Thank you so much.
Thank you. Thank you, Mr. G.
Oh, it'll be through.
Court calls case People versus Tyler Clincher.
Good afternoon, Your Honor. James Murray, PA 5490, appearing on behalf of Mr. Clincher, who is present, consents to holding this matter via Zoom. Please state your name for the record.
Tyler Clincher.
All right. And what are we doing?
I've had a chance to speak with the people in this, but we can set this for an exam.
All discovery is complete?
I believe so. I have a police report. If it's no digital discovery, then we're all set.
There should be digital discovery.
You should have video digital discovery. You don't have everything.
No, if the people can send over the digital or one more time, that would be perfect.
Well, I'm not going to set it for exam until you have everything, being able to have it and then review it with your client. So what I will do is you'll get that over to them.
Yes, Mr. Murray, if you could send your appearance to PA Discovery.
Oh, it wasn't sent. Okay. So you got to send in your appearance to, what is it, PA Discovery?
At washington.org.
At washington.org.
PA. Okay.
And then all of the discovery will get to you. I will adjourn this out. I can do the 13th or the 20th. Which one would you like, counsel?
13th.
Why I'm asking people. 13th? November 13th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls the case of the People versus Gary Coward.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Gary Coward. Gary Coward.
Thank you. What are we doing?
Your Honor, we're asking for a brief adjournment in this matter. Trying to
All right.
resolve it at the district court.
November 13th.
Could I have the 20th, Your Honor? Sorry, Judge. I'm on trial that week. Sorry.
I'm just going to stop being nice. This is why I'm not nice. November 20th, 2025, 9 a.m. No objection from the people.
No, sir. Mr. Burgess, if you want to email me in advance of that date, I can get you what you need.
Thank you. Appreciate it.
Bond will continue. Thank you.
Thank you, Your Honor. All right, thank you.
Court calls the case. People versus Jermaine Mills.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Christina Costantino, Your Honor, I'm standing in for Attorney of Record David Goldstein. Mr. Mills, can you please state your name for the record?
Do you have any objection to Ms. Constantino stepping in?
No, sir.
All right, very good. All right, what are we doing?
Your Honor, I've heard from Mr. Goldstein that they have likely came to some sort of resolution that will likely keep this matter at the district court, but they do need a bit of time to facilitate that. I would never ask to pick my date, but Mr. Goldstein has asked me to ask if
So it's Goldstein picking?
he would ask for a 1 week adjournment, given that
Oh,
it
1
seems
week?
they've resolved.
I tell him no. I can do the 13th or the 20th.
All right.
Do you think, hold it, have you resolved it and it's just a matter of paperwork, or do we know?
There's some other district court matters that he's trying to work out a global resolution on. So Mr. Goldstein is locked in tense negotiations with Mr. Chabalowski.
Oh, boy. I'd like to see that happen. Anyway, here's what I'll do. I'm going to take the 13th if he's trying to resolve everything, and then we'll try to get it there. If he needs another day, he can get in contact with my office and let his client know that he'll need another day. Is that
Sounds
fair
good.
enough, sir? Sir. Set it for November 13th, 2025. 9 a.m. bond will continue. Thanks.
Thank you very much, Judge.
Thank you. Have a good evening.
Have a good rest of your day and a happy Halloween.
Wow. Wow. Oh, to you too, or whatever it is on this day. All right. Take care.
And there you have it, ladies and gentlemen. It's been a Thursday. It's been October 30th all day long. And that's what we have. The court had a little bit of Hesselink, a little bit of DeSantos, and a lot of Judge Simpson. Thank you very much, ladies and gentlemen, for suggesting the audible in the very center. That was a fun little change up. I was happy to make that happen. Come on by every night of the week. Same Wolf time, same Wolf channel, and come by and check us out on Saturday, 11 a.m. Central Time. That's noon Eastern Time. I'll be right here showing a little bit more court for you. And ladies and gentlemen, come by tomorrow. I don't care if it is actually October 31st and Halloween and it's Friday and it's all that good stuff. I'm going to be watching court. I hope you're going to be watching court here with me too. Thank you very much. This has been a special live presentation of Lone Wolf's Court Gallery. I am your Lone Wolf. The stream boss is behind me. And he's giving me these looks, like if I don't shut up and let the stream in, he's gonna claw me in the back of the head. So ladies and gentlemen, have a very good night. Thank you very much for everybody who came out tonight. And most very much thank you to Granny 3 times over and Rhonda for all of your kind donations. The stream really needs it and the stream really appreciates it. And I really appreciate all of you. I'm your Lone Wolf. I'm your curator. Y'all have a great night. Peace out. What? Is it like an expectation thing at this point? Every time I do a live, there has to be Ferris Bueller Day Off reference. Every single time? Every single time? No. Go, get out of here. Not doing it. Not this time. Nope. Bye. Wait, I already did it, didn't I? That was literally doing it. Dad, gummit! Foiled again! Night, guys!